Defense made a motion for a mistrial. Prosecutor was up to some fuckery. Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked right down the path and asked the question. It may be over on Tuesday morning. Batman Bruce Wayne bitch snitch. Gerald Brooks, your constitution does not apply to me because I'm a sovereign citizen, a traveler on the land, I'm the Moorish Empire or whatever, bitch snitch. Because they're so fucking absurd. If you want to be a sovereign citizen, just do yourself a favor first. Go to YouTube here and just get every sovereign citizen that's ever been before. Find me one that won. God dang, you're right. Don't go down this. It's not the path. Don't have time for stupidity. Some clever dick on the internet didn't find the great loophole in all of the world's law. Bitch snitch. God dang, you're right. God dang, you're right. Traveler on the land. God dang, you're right. Moorish Empire. Traveler on the land. Bitch snitch. Moorish Empire. God dang, you're right. Traveler on the land. Bitch snitch. The late evening U.S. people.
What do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God! No!
Hey, good morning, good afternoon, good evening, good night, whoever you are, wherever you are, whatever you're doing, whoever you're doing it with. I'm just glad you're doing it here with me. Legal Vices on this little old channel I like to call Legal Vices. Because I'm kind of clever that way. Well, we have a lot to catch up on. We spent a lot of time dealing with the other Judge Grudge case involving Judge DeThomasis and the same lawyer that was in the What the Hales case and the same judge that was in the What the Hales case going head to head in another case involving another protective order and more bias from the judge. So we spent a lot of time on that. It's time to catch up. We've missed a few things here in Sarah Boone land, and we got to make that right with you guys. We got to do it right. We've got a lot of motions, a lot of motions to get through. We've got an interview with Sarah Boone's new lawyer to get through. We've got a hearing to get through and more motions to get through in that order. And just a quick note for those of you that aren't watching me on Rumble right now. For some reason, the stream did not start on Rumble as it should have. So I don't know. Your guess is as good as mine. So I don't know why. I don't know why I didn't do it, but it didn't. So all right, it's just here on YouTube today. Sorry if you had any desire or plans to watch it over there. Just didn't happen for some reason. But I'll upload it to Rumble later. So with that out of the way, I think we need to set the stage here. But by doing that, I think we should Sorry, I was just a little discombobulated there by whatever is happening on Rumble. Give me 2 seconds to deal with the Rumble situation. I don't know what it is. But still says waiting for stream offline, which means I'm just gonna end that stream. Yes, I want to end that stream because I have no idea why it didn't start. So, all right, Rumble's gone for today. All right, we need to backtrack a little bit and find out where we are. Well, one of the important things to note is that Sarah has been doing her best by herself. She said it before. I don't know how to be a lawyer. I don't know what the rules are. I'm doing my best. Her best was much better than I thought it would be, but it was nowhere near adequate. It was nowhere near enough to really help her position. Well, things have happened. She's got a new lawyer, and he stepped up to the plate. We'll find out a little bit more about him and why he undertook the case. I'm sure a lot of you have already seen the interview, but I'm going to give you my take on it, my perspective, as well as the backlog of motions that have been filed in recent days. And real quick, by way of the housekeeping stuff, we have a like and subscribe poll set up. We are now less than 1 month away from the scheduled start of the Sarah Boone trial. The trial is supposed to begin on October 7th. The big question right now is, will it happen on October 7th? The judge has been pretty adamant that it's going to happen at that point in time, but also the new lawyer is making some moves to try to change the hearing date. And we'll bring you up to date with recent filings within the last couple of days to maybe set the stage for something. We'll cover that. So the like and subscribe poll today is just it's a basic like and subscribe poll. The only reason we have a like and subscribe poll is to remind you to like and subscribe and do all the YouTube-y stuff. Invite your friends, share the video with others, and let's proceed with the like and subscribe poll. Will the trial ultimately be delayed? Will it be delayed beyond the October 7th start date? So for 54% of you have said yes, and 46%, and now it's 55 and 45. 45% say no, 55% say yes. We'll check back in a little while and see how that's changed over time. We're continuing our march to 81,000 subscribers, and you are the only people that can make it happen. You here on the live stream that are just stumbling into the channel and wondering what the hell's going on, Sarah Boone's going on. Those of you that are watching on the replay crew that may have seen this somewhere on the YouTube front page or whatnot, subscribe. And if you are subscribed, I implore you to please just double check to make sure you're still subscribed. And that's the last like and subscribe stuff we're going to talk about for at least an hour. Doggo Cam is locked and loaded. If we reach the appropriate level of support, I guess is a good way to say it, we will unleash the emotional support Potato Pig Dog Cam as usual. And on the unexplained stream we had the other night with Danny on direct and Flux and my good friend Crown Fox Production, where we talked about Bigfoot, we talked about ghosts, we talked about mediums. And there was a lot of love shown, and we have the emotional support Potato Pig Dog Cams, which some people say I'm holding my dogs hostage behind a paywall. No, it's just a reward to you for showing support. But also at the next level achievement is sort of your revenge for me holding the dog behind a paywall. If we get to the second level achievement, I take a shot of a really, really unappealing and not very good whiskey. Take a shot of that as a punishment and your revenge for the dog cam. We got there, but I didn't on Saturday. I promised I would do it today. The hate shot, the revenge shot for the second tier is a shot of Kirkland blended Scotch whiskey. No age statement, just Kirkland from Costco blended Scotch whiskey. It's so bad. I've had this bottle for 5.5, 6 years, and this is how I'm getting rid of it. So cheers. Thank you for the support on last Saturday, and we'll see how it goes today. Delicious. I can't believe I used to like that. All right. That resets the counter. The emotional support potato pig dog cams, both of them are here today. We'll see how that happens. And I hope I don't have to do another one of those, but all right. Sebastian Muller has been a member for 17 months. Remember to hit the like button and subscribe. Hey. Can't say it any better. And Sebastian Muller, one of the OG gangsters. Thank you so much, Sebastian. Don't drink it neat. Well, that's the point. That's mellow corn is not better. That is a false statement. But mellow corn is not actually that bad. It's not that bad, but I would have to give the nod to Kirkland non-age statement blended Scotch whiskey as being better than mellow corn. Right. That's it. Let's get into Sarah Boone because we have massive. Oh my Lord in heaven. Never mind. See, I was just getting. Oh, hang on. How dare you derail my show with your gifted memberships and super chats? How dare you? Hang on. I have to get things set up that I was not expecting to happen quite so quickly. Right. We have to prepare the emotional support potato pig dog cam for launch. Let's see. I'll stare over there for a second. Ooh, that whiskey is hitting the stomach now. Ugh. All right, we've got to get the sound effect. Okay, there we go. Kicking us off with the first super chat of the day. Island, free the furry hostages. You started us on our journey with the very first super chat of the day. Sonny or Chris with the 20 Legal Vices memberships. Woohoo! Thank you so much for the 20 Legal Vices memberships. If you were one of these lucky 20 people that got the Legal Vices membership, hey, people, make sure you give Sonny or Chris a super special thanks. And between Island and Sonny or Chris, that gets us right to the that part of the show that we just love to call Release the Hose. And we introduce our co-host for the day. This is Strawberry, looking particularly sad for some reason today. That's Strawberry. Yoda is literally right under the camera, so I can't focus on Strawberry on Yoda right now. And maybe thank you so much. What the hell? You can paywall your own dogs, man. People are entitled. No, they're not. They're not behind a paywall. They're a reward. They're a reward to you as you unlock the achievement. I don't hold them hostage behind a paywall. That would be terrible. That would be bad of me. All right, we've had our 15 minutes of BS, but that's a false statement. They're a reward to you for support. They're not held behind a paywall. I would never hold my dogs behind a paywall. All right, potato, whatever. All right, Sarah Boone, as I was saying, is in court. She is scheduled to go to trial on October 7th. And weirdly, her birthday is October 10th. So she'll be if everything all goes according to plan, opening statements should start on her birthday. I assume they'll take a day or two to seat a jury. So yeah, her birthday should be right around opening statement time or the first witness time. All right. I'll see here. You can see there's Yoda right under the camera. But we'll just focus on Strawberry for now. Oh, KT's birthday is August 6th. Will she get a postponement for her birthday month? All right, we are sharing the screen, and on this shared screen is the first of the motions we are going to look at today. This is the first of the motions we're going to look at today, and unfortunately, people, at least for now, the last of the Sarah Boone handwritten motions that we're going to see in this case. She's got a lawyer. He's got a computer and he knows how to type. In the Circuit Court of the Ninth Judicial Circuit in and for Orange County, Florida, State of Florida, plaintiff versus Sarah Boone, defendant. Motion for payment of costs and appointing neuropsychologist to assist the defense in preparation of the defense. So to assist the defendant in preparation of the defense. She's asking to appoint a neuropsychologist and for the state, meaning you people in Florida, to pay for it. She's got we've got the magic words here. Comes now the defendant Sarah Boone by way of pro se respectfully moves his honorable court to enter an order authorizing the state of the Florida to incur costs of the following discovery expenses. Ding, 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 ding. Incense, swing, swing. Okay. The magic legal words have been said. She's asking for the following discovery expenses. 1, reasonable fees for a neuropsychologist. Hugh Jazz says, is she planning to plead insanity? 4 or 5 motions from now, we'll answer your question. Reasonable fees for a neuropsychologist. These services include the reviewing of documents and physical evidence, writing of reports, travel, and trial testimony. As grounds, the defendant states the following. Defendant is charged with second-degree murder, which carries a life sentence. Defendant has been adjudged indigent for costs. She ain't got no money. And C, defendant has no income. She ain't going to have no money and cannot afford the services of a neuropsychologist. A genuine issue exists related to this case, which will require the assistance of an expert witness in the field of neuropsychology. She's saying that there's something about this case. There's an immaterial part of this case that requires the assistance of a neuropsychologist. J. Katie Bugs says, grounds. Ain't no grounds here. Moving on to E, defendant is without funds. She already said that, and does not have the ability to pay the costs associated with an expert witness to assist in the defense of this matter. Therefore, she requires the assistance of the state of Florida to guarantee protection of her right to the process and effective assistance of counsel. No. You want a neuropsychologist, not effective assistance of counsel. You already asked for that and said you ain't going to get it unless you pay for it for yourself. But please stand by. She has a new lawyer. She should have said her to guarantee protection of her right to due process and ended it there. Pretend you didn't see the and effective assistance of counsel part. You could have asked one of her 9 lawyers ago. We'll talk about those 9, the previous 8 lawyers in just a minute. Counsel has contacted neuropsychologist Dr. Hyman Eisenstein, or Eisenstein is Frankenstein. Yeah. Frau Blucher? All right. Frankenstein. She has contacted neuropsychologist Dr. Hyman Eisenstein. I think we're just gonna use the horse. We don't have a Frau Blucher, so perhaps Hyman Eisenstein can be the person here. That triggers the horse. Hey, Trigger was a horse. Trigger. That was the Lone Ranger's horse's name. Get it? Hey, connection. Ooh, how was that? MG Law said the magic words Blucher. Hey, see, so there we go. I'm sorry. That was childish of me. Defendant intends to engage the services of Dr. Hyman Eisenstein. Dr. Hyman Eisenstein, it doesn't reload that fast. Dr. Hyman Eisenstein graduated from the University of Chicago, Division of Biological Sciences. The Pritzker School of Medicine in 1982. He works in Miami Beach, Florida, specializing in psychology. H. Defendant seeks permission to allocate funds for Dr. Hyman Eisenstein services at a rate of should I, 1 in chat if I should stop doing that and never do that again, and a 2 in chat if I should continue being childish like that. Let me hear it. Allocate funds for Dr. Hyman Eisenstein's services at a rate of $300 per hour for all work performed on the case except travel time, billed at $125 per hour with an initial cap of $15,000. Oh no, it's looking about 50-50 in the please don't do that and please continue it. But I think the twos, okay, the twos don't ever do that again. I'm not reading that, Flux. The twos never ever do the Dr. Eisenstein horse thing again. Okay, the twos have spoken. I won't do it. Okay, I'll try not to do it. So she wants this guy to be billed at a rate of $300 per hour, except for travel, which is $125 an hour with an additional cap of 15 grr, plus reimbursement for all reasonable and necessary related expenses, including but not limited to travel expenses, lodging, meals, mileage, postage, shipping, and document reproduction, and is a service provider with the JAC. Now, the JAC, they're going to have a response to this in the next document we read. I just swapped them up. Which did I just swap? I don't know if it's Eisenstein or Eisenstein, so I'm just calling him whatever I feel like, whatever comes out of my mouth. All right. Defendant cannot properly prepare for trial until expert analysis is complete. Defendant has attempted to request this evaluation through her previous appointed attorneys without success, based on several factors, to include the attorney not being able to locate the proper specialist in this field of neuropsychology, the willingness, okay, this is a problem, the willingness of the neuropsychologist to work the case. You can't force someone to be your expert witness. Say, hey, we need a neuropsychologist to look at this issue. The neuropsychologist looks at it and goes, I ain't touching that with a 10-foot professional pole. Ain't no way I'm testifying to that. You can't force him to do it. So the willingness of the neuropsychologist to work the case, that might be a big problem. And the authorization of the JAC to pay for said neuropsychologist. K, defendant believes that her pattern of behavior, foreshadowing. This is the harbinger of things to come. Defendant believes that her pattern of behavior stems from a lifetime of mental and physical abuse and believes that she cannot have a proper defense without a neuropsychologist who can evaluate her exposure to this trauma. A neuropsychologist specializes in understanding the relationship between the brain and behavior. Given the complexity of the defendant's mental health history, it is critical to assess her cognitive function and mental state to determine how these factors may have influenced her actions. Strawberry has pieced out to go drink some water. I can hear her lapping up the water. So in the meantime, we'll just focus down here on upside down Yoda. It sounds like Strawberry is swimming when she drinks water. Right. So where are we here? Okay. She wants to have the neuropsychologist talk about how her history of trauma has affected her actions. Wherefore, the defendant, Sarah Boone, by way of pro se, respectfully requests to this honorable court in conclusion for payment of costs and appointing neuropsychologist to assist the defense in preparation of the defense. More magic words. Oath. Here's her oath and the certificate of service, which she's so very, very carefully handwrites. And we do not want to save any changes. Negative. Go away. Well, that was our first motion, people. That was the first motion. So she wants a neuropsychologist. She wants the people, the good, upstanding citizens of the state of Florida, to pay for it. Let's see where we are in this chapter. Mayville. No, I'm not. I almost read her super chatting. Okay, Sonny or Chris was triggered. Triggered was Roy Rogers' horse. What the hell was the Lone Ranger's horse? Silver. Hi ho, Silver away. That's right. Wow. See, this is what happens when you live in Korea for 36 years. It's been a minute since I've watched The Lone Ranger. So yeah, you are correct. I stand corrected. Trigger was Roy Rogers' horse. You are absolutely correct. And yes, the Lone Ranger's horse was Silver. Thus, at the end of every episode, hi-oh, Silver, away. You are so nice. I stand corrected. Thank you. Thank you for paying $5 to tell me that I was wrong. Sometimes I'll admit to being wrong. So she handwrites this and claims reduced mental state. Hey, and her handwriting is quite nice. So Eisenstein pronounced, means ironstone, steen like in pronounced like English I, Stein. Eisenstein pronounced. What does that mean? Are you saying it's Eisenstein or Eisenstein? But we all know that it's not the Bernstein Bears, it's the Berenstain Bears. And that was the thing that the Berenstain Bears Mandela effect is a real thing. I would have sworn until 5 years ago on the life of everybody I know that it was the Bernstein Bears. I still think they changed the name just to mess with us. No, Trigger was not the Lone Ranger. How could you be so foolish as to think that? Trigger was Roy Rogers' horse. Come on. Lone Ranger's horse was Silver. We all know that. Eisenstein is what we're going to go with. All right. The World According to Anne Catherine Boyson. That's what we're going to do today. But I don't think we're never going to have to say his name again. But thank you. Right. So that's the that's her motion. I've got the other motion locked and loaded here. Before we get into that, I just want to say hi to the 449 people watching. Thank you so much. Thank you so very, very much for that. To the YouTube things, like and subscribe. I said I wasn't going to talk about that for an hour, so I'm not going to tell you to like and subscribe. But yes, here we are. The next motion, the next court document filed is the response from the Justice Administrative Commission, the JAC, to her motion for costs and appointing a neuropsychologist. Let's see what the people that provide the funding for all this have to say about that particular motion of hers, shall we? Oh. Strawberry has returned. Yoda is snoring. So there you go. Dog butt. Woohoo. What are you chewing on, Strawberry? What do you got in your mouth? What do you got in your mouth? Okay, she doesn't have the inappropriate dog toy in her mouth. But Aussie Wombat has just dropped the hammer on 5 Legal Vices memberships. If you happen to be Huge Ass, if you happen to be Nortreth, Terry M., Anthony Bray, or Jules, make sure you give Aussie Wombat a super special thanks for the Legal Vices membership you just got. And either next weekend, not this weekend, like the following weekend or 3 weekends from now, will be the September members only stream. Please stand by for that. Thank you very, very much for that, Aussie Wombat. You are awesome. All right. So back, as I was saying before, I was forced to read that chat. We got the JAC's response to the motion for payment of costs and appointing neuropsychologist. Let's see if they give her the neuropsychologist money, shall we? Comes now the Justice Administrative Commission, JAC, by and through the undersigned attorneys. This responds to the above cited motions as follows. Ding, 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 incense, swing, swing, swing. Okay, magic words out of the way. The defendant is seeking authorization for $15,000 at a rate of $300 per hour services and $125 per hour for travel for a specialized mental health expert. Based on JAC's record, the court previously authorized $3,000 at a rate of $200 per hour for a defense mental health expert. Well, JAC may only pay for due process costs pursuant to sections 29.007, James Bond 29.007. 27.40 and 27.5304 2 Florida statutes. As directed by Section 27425 Florida statutes and the General Appropriations Act, all due process services are subject to the Florida statutes and the JAC contract, policies, and procedures. JAC objects to any compensation rate in excess of established rates. The rate for a psychological examination is a flat fee of $350. For other services, the established rates for medical doctors and psychologists are as follows. In-court testimony, $170 for first hour or less, and $170 per hour thereafter. Waiting to testify in court, $85 an hour. Dude gets paid $85 an hour to sit on his ass. Waiting to testify for deposition, because depositions aren't quite as bad as sitting in court apparently. So you get 85 if you're sitting on your butt waiting for the trial for your chance to testify, and only $72.50 per hour if you're waiting to testify at a deposition. I'm not sure why there's a difference, but there is. You only get $72.50 for travel time, not $125, I believe it was she was asking. Out of court services, $160 for the first hour or less, $160 per hour thereafter. Malin Lindstedt, if you got your membership today, and I didn't just read out your name, it was probably Sonia or Chris earlier today at the beginning of the show. If you didn't get it today, I got no clue. So that's it was probably Sonia or Chris at the beginning of the show today. All right. The defendant has the burden to show the particularized need for an additional mental health expert. Denise Sells just got an email from Rumble saying that they're being banned in a few countries. That may affect Jeff's ability to connect or activate the server. No, it was probably just a little glitch in the system. I can still access it. I can still set up streams. It just didn't trigger. Just like Roy Rogers' horse trigger didn't trigger after a while. But yeah, it just didn't start for some reason. But I can still access it and set things up. So thanks for the heads up, though. That's interesting. All right, so they're saying she has the burden of proving why she needs another mental health expert. She needs to prove the particular need for a neuropsychologist. As enunciated by the Florida Supreme Court, a party seeking due process costs has the burden to establish the following: 1, the particularized need for due process services, and prejudice arising from the denial of the due process services. There's a couple of quotes for cases that are cited there. The determination of whether to appoint an expert is within the broad discretion of the trial court. An indigent defendant must show the trial court that there exists a reasonable probability both that an expert would be of assistance to the defense. So she's got to show that the neuropsychologist would reasonably probably be of assistance to her, and also that the denial of the expert's assistance would result in a fundamentally unfair trial. There's a couple more cases that are cited for that principle of law. The defendant also has the burden to establish diligent efforts to obtain services within or closer to the rates established by law. Assuming the defendant establishes that particularized need for a mental health expert, the rate sought is consistent with the rates authorized for similar experts in other cases. If any providers desire direct payment, the JAC procedures require that vendor to execute the appropriate contract and follow JAC's billing and audit procedures to obtain payment. JAC does not request to participate in any hearing set in this matter. Should the court desire JAC participation, JAC requests to appear through communications equipment, that means Zoom, and can be reached toll-free at 866-355-7902. That's how you can get a hold of the Justice Commission people in Florida. Wherefore, the JAC requests, should the court grant the defendant's motion, also include in its order the specific due process services authorized, as well as hourly or per unit rates and maximum fees authorized. And the provider be paid in accordance with rates, terms, and conditions set forth by the Florida statutes and the JAC contract policies and procedures. All right, that is their response. So they're saying, hey, it's up to the judge. She's got to prove that she needs this person. She's got to prove that it's there. If the judge wants to go ahead and do this, the judge can go ahead and do this, but we don't want to be part of it. If you think we need to be part of it, you know where to reach us. And so there was, they said, we basically got no opinion. Just she's got to prove it. Got to be in the rates. And there we go. Well, now a couple of other things have happened. One of the things that happened was she asked the JAC for money to pay lawyers. that was granted. And as soon as that was granted, all of the other lawyers, I believe all of them, if not all of them, a very large number of the previous 8 lawyers came forward and said, we want money. We want to get paid. And so they all filed, the ones that filed the motions. So, yeah, that was interesting. But that I didn't want to cover those motions because they're just basically give us money things. So yeah, wasn't too interested. Well, then following that little bit with the JAC and the application for a neuropsychologist to be appointed, something very, very interesting happened. A motion was filed. A motion was filed in this matter. And let's bring up this motion. Let's see. There we go. Whoops. All right. This is here in the Superior Court of Florida, referred to judge. This is a typewritten motion. Sarah Boone restrains placed on arrest and booking once in jeopardy, blah, blah, blah. This argument. Motion to dismiss case and charges with constitutional authorities. All right. Well, what is this all about? A motion to dismiss authority. The Constitution of the U.S., Amendment 6, specifically the right to a speedy trial, has been violated. All right. This is Sarah Boone allegedly arguing that the Constitution has been violated, specifically Article 6. The state of Florida has not met the requirements or proven good cause of delays. Ineffective substandard state provided attorneys. So ineffective, it should be ineffective. That's a serious typo. So this would tell me a lawyer, because this is not the usual handwritten stuff. This is typed. This is typed out. It's clearly not typed out by a lawyer, because a lawyer wouldn't do this, and ineffective would be spelled correctly. But so we have this ineffective substandard state-provided attorneys should have made this request long ago, proving this as a fact. It says here the authority of the Constitution of the United States. The supported evidence is actually the first 7 amendments of the Bill of Rights. This is the evidence attached to this. And of course, if you're wondering, the 6th Amendment says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witness against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Now, this was filed, typed out by someone that's not a lawyer. And so once this was submitted to the court acted on it. And here is the court's response. Let's get this here. This is the court's response. Order striking motion to dismiss case / charge, S sick with constitutional authorities. So the court is issuing an order striking the motion. That is taking it off the books, pretending that it never happened. Striking it is it's the same as saying this never existed. This cause having, hey, where'd my comments go? There we go. This cause having come on to be heard before me in chambers on August 29th, 2024, upon the motion to dismiss case charges sick with constitutional authorities filed August 27th, 2024, and in court having reviewed the motion and the court file and being otherwise duly advised in the premises hereby finds as follows. This is the court's finding. The motion was received by this court on or about August 27, 2024. The motion was filed by a non-party. It was filed by a non-party. And such, it is therefore ordered and adjudged as follows. This motion is hereby stricken, done and ordered. This is the 29th day of August 2024 in chambers in Orlando, Orange County, Florida. So what happened was someone who was not Sarah Boone, was not a lawyer for Sarah Boone, was not the prosecutor, was nobody involved in this case, filed a motion for this to be dismissed on the grounds of violation of the right to a speedy trial. It turns out that the motion that we just read, for what it was worth, came from apparently a random person in California, completely unrelated to this case as far as anybody knows. So the judge said, sorry, whoever sent that, you ain't a party to this. You don't get to make the motions. So it's stricken from the record as if it never, ever existed. So I found that to be very, very interesting. I thought that was kind of a fascinating thing that somebody would do that. Well, now here comes here's the major development in this case. This is the major development. State of Florida plaintiff versus Sarah Boone defendant. Notice of filing. Please take notice. This isn't the big one. This is the next big one. Please take notice. The court hereby files the following in the court file. IMS records from Orange County Jail per the memorandum of the Orange County Corrections Department. This deals with a serious issue that Sarah was arguing. She has access to this laptop computer. It's supposed to be charged and ready for her, and apparently one morning it was not charged and ready for her, which she complained about. And I think she has absolutely every reason to complain about that, because it cuts into her allotted time to be able to prepare for her case. So let's see what happened here. Inmate Boone Sarah, currently pro se, and is allowed a laptop scheduled hours of the day. Inmate Boone, currently pro se, and is allowed. What? Okay, I just read that. The laptop had a low battery and needed to be charged. An entry was made hours ago by this officer regarding the battery, and also inmate Boone requesting an Op 60 statement form. While collecting the form from inmate Boone, I informed her, why is form in every case spelled FIORM? While collecting the FIOR form, I FIORM'd her. There must be some sort of glitchy thing going on here. I informed her that the laptop is now charged and should be ready for use. This is weird. And I told her that I would make the day shift officer aware that the laptop is to be charged once she is finished with it, so that she can utilize it during the night shift. Inmate Boone then stated, Ms. Ford, I will take the FIORM back. I didn't really want to turn it in. It's okay. I will keep it in my documents. Just please let the officers know that it has to be charged. I can't do anything without it. I gave to her the FIORM back, and Sergeant Moreno was notified. This entry is FIOR documentation purposes only. I really, really want to know what this every time there's an FO, it's FIOR. I really want to know what that's all about. There's no hint in this document as to why every FOR is FIOR. Anywho, another interesting thing was here. All inmates were given an opportunity for shower time, and the evening shower was available and offered, but inmate Boone verbally refused her evening shower. Okay. Then this is just sort of the list of the times she was given the hard drives and whatnot. Now, Corporal Pagan and I engaged in a discussion with inmate Boone in the FTC briefing room regarding several matters. We addressed the proper channels for submitting request forms, emphasizing they should be directed to the housing officer. There's action taken She's been incarcerated since 2020. She's already well acquainted with the established procedures and confirmed her understanding of them. Inmate Boone expressed a desire to have a tablet available for use throughout the day. We clarified that tablets are accessible to all inmates on a standard schedule 7 days a week, ensuring reasonable access without the need for further action. The inmate also requested that writing materials such as pen and paper are replenished as necessary. Request denied at my level and escalated to the appropriate authority. So she basically wanted free pens and paper. The appropriate authority provided guidance in compliance with our policies. Inmate Boone is directed to request her items via inmate request forms to the law library department, and no further action is required. Inmate Boone demonstrated a willingness to engage during our dialogue. However, and this might not come as a surprise to anybody that's familiar with this case. However, she consistently paraphrased my statements while introducing details that were neither mentioned nor implied. Consequently, I concluded the conversation and dismissed inmate Boone back to her unit due to her patronizing tone and her persistent misrepresentation of my remarks and the information I aimed to communicate. Ultimately, inmate Boone expressed her disagreement with my stance and decision-making, indicating her intention to file a motion with the judge assigned to her case. Yes, and this is just laptop in, laptop out stuff, thumb drive in, thumb drive out stuff. But I thought that was interesting that she was there was a problem. Apparently there was a problem, and the laptop wasn't charged appropriately the way it was supposed to be charged for her to use. And she had every right, I think, to complain about it, and she did. And then there was involved in other things she was requesting. She got a little bit patronizing apparently, and was misstating things that were told to her that not to be unexpected. It didn't strike me as anything that was unexpected. Well, now we have something. This is the point that a person stepped forward. This is the major development. This is the biggie. A gentleman stepped forward, a man named James Owens. James Owens from Milton, Florida, stepped forward and submitted the proper and necessary documents to say that he is now officially Sarah Boone's new lawyer number 9. Number nine. He is her number 9th lawyer. And Wishful Wen is the newest member. She's got a new lawyer. I got a new member. Thank you, Wishful Wen. Welcome to the Clean and Sober crew. I hope you'll stick around. Oh, just wait. Hugh Jass says number nine. And I can't remember, says, do you think she'll fire him during the trial? Well, apparently he walked away and she almost fired him before he was even hired. But we're going to get to that here in just a little bit. And by a little bit, I mean right now. Right now, we're going to be looking at the interview that he did with Court TV. He interviewed with Court TV's Vinny, and Vinny asked him some, I thought, very good questions. So let's take a little bit of a look at the interview by telephone with James Owens, Sarah Boone's 9th lawyer. Oh, and for those of you that wonder what I watch on YouTube, Emily Baker, but this is not an Emily Baker stream. This is StreamYard. The people at StreamYard that I use StreamYard as my streaming service. StreamYard interviewed Emily Baker, and I'm a big fan of the vocal analysis here from the charismatic voice. I like her vocal analysis. Earlier today, I was watching her analyze Lemmy's voice on Ace of Spades. It was her first Motorhead experience. She's an opera singer, and that was her first Motorhead experience. It was quite interesting to watch. We've got the lawyer who's also talking about lawyer number 9, and Motion to a hearing from Laurie Shaver. We've got Nico Leonard. He's probably the premier watch guy on the internet, and 12 disturbing details of Georgia school shooting. So those are the things that crop up on my feed. Good thing nothing else weird showed up.
So who would believe in Sarah Boone? Well, someone did step forward to take this case.
Now, I have to take exception with that statement right out of the gate. Who would believe in Sarah Boone? I don't think.
Yes, an attorney.
Shut up, Vinny. I don't think you have to be someone who believes in Sarah Boone, or you certainly don't have to be someone that believes Sarah Boone, but I don't even think you have to be someone that believes in Sarah Boone. You just have to be someone who thinks she has a right to counsel, and you decide to represent her, whether you agree with her, whether you like her, whether you think she's being honest or not. If you believe she's being dishonest, you're limited in the things you can do, but that doesn't prevent you from representing her and making sure that her rights are protected. So, Vinny, that's kind of a dorky look, but so let's move on.
Florida. Joining me by phone,
someone who believes in her right.
Sarah Boone's ninth attorney, James Owens. James, thanks so much for joining.
And James is a very, very well-established criminal defense lawyer. He's been elected, I believe was it a county public defender before? I mean, he is good at what he does. He has a very, very long track record of doing these things. He's not a fly-by-night lawyer. Lamau, I hate this dude. Vinny's a little over the top. Vinny can be a little aggressive, a little over the top.
Joining us tonight.
Thanks, Vinny, for having me.
Okay, the first question I know everyone's asking you: why? Why did you take this case, James?
That's a very good question. And that literally is the first question that everybody wants to know. Why did you take this case?
Well, I watch a lot of YouTube, and I watch a lot of court TV, and I've been
James, watch Legal Vices. This is where you should be watching. Legal Vices. Watch me. I'm better than court TV. You can watch court TV and me at the same time, James. Just saying.
Following this case, just like all the other true crime people do, and kept watching it being delayed, and the lawyers being switched, and then saw that the judge got fed up and ruled that she had forfeited her right to a court-appointed counsel, and so. That's a rare event, as lawyers, we know that, everybody has a right to a lawyer, a court-appointed lawyer, if you can't afford one. So on a serious charge, a felony, in this case, it was a murder, for the judge to revoke that right was a serious decision on his part. I don't disagree.
And see, that's one of the first interesting things. One of the first things, I shouldn't say this, one of the first interesting things he said. That sounds bad. One of the first things he says is an interesting thing. It's extraordinarily rare for a judge to decide that someone has just waived their right to a court-appointed counsel by their own behavior. But he says that he doesn't disagree with the judge's decision in that regard. So, I think he knew what he was getting into. If he didn't know what he was getting into when he first reached out to her, he certainly knew what he was getting into before he finally agreed to represent her. Because we'll talk about that here in a little bit. You kind of like this dude. Which dude? The lawyer dude? I like the lawyer dude. I was watching, I think it was Lawyer chat. I mean, they were all like up on this lawyer. He's a publicity hound. He's fighting for money. He needs the attention. Listening to the guy talk, I think he's just a genuine guy that's got some free time apparently. And he's like, hey, look, this person needs a lawyer. I don't get any of these ambulance chaser, grifter, attention hound vibes from him at all.
I respect the court's decision, but that left her facing a murder charge without a lawyer, which is unheard of, I think. And so, I watched for a while, and then I saw the ad on your show.
Hey, officer, what's up?
And
so that's another interesting thing he said. Remember that ad that she basically looked like a handwritten Craigslist ad for a lawyer? It was pretty amusing. It was pretty funny to read, but he saw that and went, I think I'm going to take that seriously. No, that's what he said. The Thumpa Harley, that's what he just said. He saw her advertisement when they showed it on Court TV. So yeah, he did see her awesome poster, and that's how he got involved in this. So that's another interesting thing. Her ad worked, people. You all were making fun of it. You all were just you were giving her a ton of shit for that ad. Guess what? It worked. She got a lawyer out of it.
I think that you had said something implying, hey, who's gonna take the case? What lawyer in Florida is gonna pick up the torch, so to speak? And I think you had somebody on, maybe it was a lawyer from the Northeast, and I think I remember that lawyer saying, man, if I was a license in Florida, I'd take the case, under that scenario, because she really needs a lawyer. Everybody needs a lawyer. And so the ad came out, and I sat there and waited for 3 or 4 weeks. I can't remember now how long I waited, but I was thinking that a lawyer out of Orlando would pick up the case. Somebody would think, hey, this is not right. There's no way she's going to get a fair trial representing herself. It's unfair.
And that's something that I believe we've all said. That she's not that she's not going to get a fair trial by representing herself. I mean, it is kind of 6 of one, half a dozen of the other, potato thing. You can say she's not going to get a fair trial, but I mean, really, again, it's just, I think she brought it on herself. She really did bring it on herself. So although it will affect her right. I mean, it will affect her ability to represent herself or to get her case across. I don't know if you can say it's not fair. It's not a fair trial. It's as fair as her behavior allowed it to be. But he is now representing her. It's not fair, but it's not unfair.
Fair, but there's a gap in the system. The judge made a decision based on her conduct that she had forfeited a right to a lawyer. I believe that's where the private sector has got to step in. Somebody in the private sector in that situation, and it's rare, should step in. So I waited. Nobody responded in the local area. So I just happened to have a case down in Hillsborough County that I was going to down in Tampa. And so
see, and that's he didn't just jump on it as soon as she needs lawyer number 9. I'm going to do it. He waited a few weeks to see if somebody else would step forward, and nobody did. And then, as he's going to explain here, he just happened to be in the area and thought he would pop in and say hi and talk to her.
Knew I was scheduled for court down there. So about a week before that, I sent her a letter, and she had a third party contact me to, I guess, check me out to see if I was legitimate. And
well, I think everyone's been checking you out in the last couple of days, and
that's the ad. That's the ad that he responded to. Young Black Economist says she only went through like 4 lawyers that were her fault. Well, the first one was the conflict between the private lawyer and the public defender, and they said who's going to represent her, and private lawyer said, all right, I'm out. Then there was public defender. They had some disagreements with a few lawyers. I think she wanted to get rid of it. Now, you guys can correct me if I'm wrong. It's because there's been so many. There's been so many. I believe there was 1 or 2 that had to drop for some reason. They didn't have to do it to her, but she wanted some of them. She wanted to get rid of some of them, and other ones just couldn't work with her. I'm going to have to go back and do, before we get into the pre-trial, for the run up to the trial. Oh, and by the way, in the run up to the trial, in the few days before the trial begins, we're going to go through and watch her interrogation videos. We watched them 2 years ago, but we will watch them again. But before we do, I need to go back and make the list of each lawyer and why they're no longer involved in the case. I can't remember exactly all of the reasons. Some of them represented Jorge. I keep calling him Jorge. Some of them George. Everybody else he even called himself George. I got to keep calling him George. Some of them represented George. Huh. 4 of them had to withdraw because of conflict. Okay, I thought it was like 1 or 2 had the conflicts. Huh. All right. Well, I guess I'll go back and look at it. But anywho, lawyer number 9 is here. That's what matters.
Everybody knows you are absolutely legitimate, James. I mean, you have quite a history.
I've been doing it a long time. Doing it a long time. So anyway, she reached out to me, and then a couple of days later, Sarah called me from the jail in Orange.
Yeah, you see that people are saying, were you the third party that contacted him? Nope, he said it was a she. It was a she. It wasn't me. So somebody associated with Sarah reached out to him, and then it got back to Sarah.
Orlando, and we talked for a little bit, and I explained to her that I was coming down that Wednesday, but I'd come down early and spend Tuesday talking to her, and she agreed. So I drove down Monday after work. Tuesday morning,
can you describe that meeting without, I know attorney-client communications is off limits, but how would you describe that meeting to someone? Like, was it different than meeting other clients for the first time?
Now, this is where we get the answer to the question that I starred a minute ago or to go. It was a statement. Lawyers are mostly going to work for a plea agreement. Stand by, because you're going to hear hints of that particular issue in what's in this what he's going to be talking about right here. So keep that in mind.
The first meeting?
Yeah.
No, it was a 4-hour meeting. I usually don't meet with clients in the jail for that long. So I gave her a chance to talk and just listened. For a long time, she had a lot to say. Obviously, she's been in jail for 4 years. And, we had a good meeting. Just, again, I think she has trust issues because she felt like she did have some good lawyers that were on her case and just withdrew because they would get in some arguments about issues, I guess. And so she said they wouldn't even tell her anything.
Bye, Franz. No, the new lawyer is not from South Dakota. He's from North Florida.
Jail, but the next thing you know, she would, be sent to court, and the lawyer had filed a motion to withdraw. So she didn't, trust the lawyers because she didn't know who to trust. She'd been with so many. So a lot of it was just trying to build trust with her. After she talked a little bit, I told her a little bit about myself. So really feeling each other out and trying to build some kind of rapport was the first meeting, which was about 4 hours. But I think early on in the case, I was able to persuade her that I knew what I was talking about because
what does Eisenstone? How do we say? We said Eisenstone. What did he have to do with horses? Nothing. It was a young Frankenstein, the movie Young Frankenstein. It was a joke related to that. He said, Frankenstein, it's Frankenstein. And then there was one of the characters was Frau Blucher. And every time someone said Frau Blucher, a horse would whinny in the background. It's just real time ADHD going on, Steve. Don't try to connect the weird dots going up in my head.
I was prepared. When I got there, I was prepared, and I played part of that 4 hours. I played the prosecutor. And
again, a very, very, very smart thing to do. I think this is one thing that, when I interview clients and things, and you always want to play devil's advocate. You want to be the other side so that they can see what type of arguments are going to be coming and what they have to do to see what they're up against, basically, and see how they respond to these things and see what they have to offer in support of their case. So it's a very, very common thing, very, very smart thing that he did there by playing the prosecutor and saying, here's the questions that are going to be asked. Here's the things that the prosecutors want to know and that they're going to accuse you of.
I pulled out the jury instructions and I made an argument as a prosecutor would make to a jury. And I had her sit there and listen to it. And I think that was effective. I don't think she had anybody ever do that to her and explain it to her that way of how it would, play out in court.
Yeah. So basically he's saying he doesn't think any of her previous 8 lawyers ever sat down to her and said, this is what the prosecution is going to say. And this is what it's going to sound like to the jury. I kind of find that a little bit difficult to believe, but again, that's just his opinion. He doesn't know what the other lawyers said. He's saying he just doesn't think that. I think a few of them probably did.
And that got her attention. And, initially I was going down there, and let me tell you, my initial thought going down there was this. She didn't have a lawyer. And once that happens, once they're pro se, then you know as well as I do that all these cases are up for negotiation. Plea agreements.
So here's the first inkling that we have to answer that to that statement that was just made that most lawyers seek for plea agreements. He's saying that he's letting us know without explicitly saying it, that he was exploring possible plea deals, possible negotiation points to try to get her a good deal.
Or pretty much on the table at any time, and judges recommend, the courts recommend, you try to work cases out. The vast majority of cases get worked out with pleas. So, I talked to her about that, and that was my intent. So
he talked to her about a plea agreement. That was his intent, was to talk to him about possible negotiations for getting Sarah Boone a plea agreement. And we know she's already turned down at least one previously. So what came of this initial discussion?
Yeah, and I'd called the prosecutor and told him I was coming down there to speak with her ahead of time, and he wanted me to file some kind of a notice of appearance, and I didn't want to do that. I wasn't ready to take on the case. So I got her to sign a document essentially saying, hey, I don't want to negotiate directly with you, state attorney. I would like for James Owens to work, just to talk to you.
So basically a limited power.
She signed that, and I did, for a couple of days, talk to the prosecutor. I was trying to resolve it.
Right. And
I felt like the judge is fixing to have a trial, a 3-week trial with a pro se defendant. Prosecutor is fixing to have a trial with a 3-week trial with a pro se defendant. It was not going to be fair. And I felt like they might be in a posture to try to negotiate something that would be doable. So that was my first intent, was not to handle the case, not to try the case. If we got something worked out, then I would file a notice of appearance, and we'd set it for a court date to resolve it.
So that his initial involvement was apparently on a limited power of attorney to negotiate with the prosecutors for some sort of plea agreement. If they can come to an agreement, then he would file his notice of appearance. They'd set a court date, and then she would plead whatever whatever they agreed on. The prosecutor would make whatever recommendations they agreed on. But that didn't happen, and why not?
So that was my first. No, it didn't. And I left that 4-hour meeting. I went to Tampa the next day, had court, and then turns out the investigator that had been assigned to the pro se litigant, Sarah Boone, he was meeting with her that evening at 7. So I asked if I could just join. So I came back over and spent about an hour and a half with her and Billy Lane, the investigator. And we talked some more, and I was convinced that there was going to be no plea bargaining. So I told her I was not representing her and I was leaving, and I emailed the prosecutor or called the prosecutor and said, look, we've reached.
Okay. So at some point he realized she ain't going to take a plea deal. And so he said, hey, I'm out. I don't want, I'm not in this. I tried to resolve this for you. I can't resolve this for you. There's not going to be a plea agreement. So I'm out. Jariah, the $2 says, Legal Vices, explain this to me like I'm an idiot. Well, 1, you're not an idiot, but 2, what is it exactly you would like me to explain? Throw that up there in the chat and I will do my best. What part of this would you like explained? and I shall do my best to respond. So I'll be looking for your, don't have to super chat, just throw it up there in the chat. So I'm done. I've done as much as I can do. I'm out. So I'm going to take off. Peace out. Good luck, Sarah. I'm not going to be your lawyer. I'm not going to represent you. Peace out. And he goes back home. And I'll wait here for Jariah's answer. But in the meantime, we'll just keep going to hear how this developed.
Reached an impasse. There's no agreement, and I'm not going to be representing her. And I went home. And I want to say a couple of days later, Sarah called me, and we talked some more. And I told her Vinny,
So, but at this point, she's now reaching out to you because she wants James Owens to represent her.
Well, we did connect. And I think she was overwhelmed being her own lawyer.
The ninth lawyer who has prestige deciding to represent her. Why? As he said, he waited for someone else to do it. He saw that this was a defendant who was not going to be able to hold her own in a murder trial that could put her in jail for the rest of her life. She didn't have anyone to represent her. Nobody was stepping forward locally to take her case pro bono or to come to some sort of fee arrangement with her. Nobody, no defense lawyers were stepping forward to help this woman out. So he decided to take it upon himself to talk to her, see if he could work out an agreement on her behalf, to give her a good shake, to give her a good plea agreement. It didn't work out. So he said, hey, I tried to do that. I can't, I'm out. I live on the other, I don't know if he said that because I live on the other side of Florida, but he's basically, look, I'll try to help you out. He tried it. He couldn't get the deal. So basically he was going to take the case because nobody else would. Which I think is a true and admirable defense attorney, one who says, look, I ain't going to make money off of this. It ain't going to be a big deal. She deserves a lawyer. She deserves representation. Nobody else is going to do it. So I will step forward and do it. So that's apparently why he's doing it. He saw the advertisement, waited for somebody, nobody did, so he stepped in and said, "All right, let me take a crack at it." It didn't work out. Now he said that they reached an impasse. He realized they weren't going to be able to get an agreement, and so he said he wasn't going to represent her. But there are rumors and reports out there that that he and Sarah got involved in a very, very loud argument and shouting match in the jail. Again, reports have it to the point where the jail staff had to come over and ask them to keep it down. All right, Strawberry. Hey, what's up? There you go. The dogs are back. So apparently it wasn't just a small disagreement. It was a shouting match. As the reports have it.
She was stressed out.
Yeah, but then she called him back a few days later and said, "Wait a minute, I just ran off a lawyer that was trying to help me. I was under stress. Please come back."
Yeah. She had all this discovery that she was trying to go over. She didn't know what she was doing. She didn't know the rules of procedure, rules of evidence. And she had told the judge, I think they'd had a couple of hearings on some issues, and she said, "Judge, this is not fair. I don't know what I'm doing."
Which is true. She said, "I don't know what I'm doing."
"I'm sorry, ma'am, but this is your position." So I think she was just.
Yes, Jariah, I think that's what it is. That he wanted the best possible outcome for her because he believes in the justice system that much. He believes that someone should at least have a modicum of something vaguely resembling a fair shake in court. Because we all know, everybody was so excited when it finally turned out she was going to be pro se. People were saying, "Oh, this is going to be hilarious. This is going to be funny." And I said, I'm excited and not excited at the same time. I'm excited because it will be hilarious and funny, and I'm not excited because it will be hilarious and funny. Being charged with second-degree murder and facing life in prison without the possibility of parole shouldn't be hilarious and funny in court. So yeah, I think he stepped in. Now he's going to get some name recognition out of this for sure. Whatever happens, but apparently he already has a very, very good reputation in Northern Florida. But he'll get something out of it. But he's going to talk about their fee arrangement here in a little bit.
Thankful that I came down to see her. We had, some good meetings. So I think she really needed some help. So I think that was partly to do with it, but there were still some issues because she was let down because I said I wasn't going to represent her.
Right.
So we got off the phone. I still said I wasn't committed to it, but I was thinking about it. But as you know, second-degree murder trial, and the judge had set a firm date for October the 7th, which is really difficult to do. I mean, you pretty much have to shut down your practice for 30 days or 6 weeks.
Absolutely.
And just to try to catch up and just which is essentially what I'm having to do. Now,
you've seen the body cam, all the interrogation videos, the 911 call, and then of course the cell video. It starts there, right? But in terms of getting prepared in 30 days for this trial, that's 4 years old and a lot of things have happened. Can you do it? And will you be ready?
Well, I'm gonna do my best with the time I've got left. That's all I can do. I'm gonna get some help. I've got to get some staff helping me. I've got a couple of lawyers that are buddies of mine that have offered their help. So
that's another good thing. Since he came forward and took her case, a couple of other lawyers have also said that they would volunteer and they would help out in some way.
I should send that lawyer from the Northeast down to help you. Joseph Krowski is the guy.
Yeah.
We'll let him know that he's the reason that you jumped in the case. He may fly down there to help you. He's up in Boston. It's cold. He may come down and help you.
That'd be great. And I've got two lawyers that, like I say, I think are going to help me. Are pretty much committed to it. They're friends of mine, and I trust them, and they want to help me. And they realize I thought the case was going to be continued. I respect the judge's decision, but I really thought.
Let me ask you this: have you spoken to any of the?
Now that's the thing here. We'll get to the motion. We'll get to this motion to continue here in a minute as soon as we finish with this. But this is one of the things where you have to say he knew what he was getting into. He knew when the trial was scheduled for. So it's I mean, he's got to try to get a continuance. I mean, it would be ridiculous not to try. But he sort of knew that the judge has been sticking with the dates are the dates for several months now, because it's gone on for years.
The other 8?
Yes. I spoke to Ms. Cashman, who was the last lawyer that had it. I've tried to speak to Mr. Padilla out of Miami. He's the one that had the case initially. He had it for about 2 years, maybe 2.5 years. He did most of the discovery, took most of the depositions. I think they were pretty much ready for trial or getting close, and he withdrew. But I've tried to call him a couple of times. I know he's been in a double homicide case they just got out of, but I never was able to speak with him.
And you're doing this pro bono?
Now here's the interesting thing. Pro bono means free without getting paid. He says no, he's not doing it pro bono. Pro bono means something. It's got paperwork and stuff. But he's going to explain why what he's doing is not pro bono.
I don't think she has much.
No.
What are you getting?
Well, Sarah's got to pay me back one day.
Okay.
That's it. He's not doing this for free. He's not doing this pro bono. He's gonna bill, and she's gonna pay him back someday. Don't count on that. No, Joe Choi. There's no ear licking going on. It's side of face licking. So yeah, he's saying she'll pay me back later.
Okay. Okay.
That was the agreement I had. I wanted her to understand that she needs to be self-reliant, and she needs to be responsible for fees. I've got a bunch of clients that are paying me, and some of them only pay $50 a month. And but it's important to me it's important to them, that we have an arrangement to make payments, and that's what I told her.
Do you think?
I feel.
Do you think she needs to tell her story?
Now, see, I like that. He's not doing it for free. She's going to pay something, somehow, some way. She might pay something. And he uses the example of other clients who didn't have any money. It's that responsibility. He's talking personal responsibility. If you just think you get something handed to you, you don't appreciate it as much as if you have to pay a little bit of something for it. If you have to pay something for it, you appreciate it a little bit more. So he came up with this agreement, I guess, that she would pay him back in some way, shape, or form, possibly in the future. John Gordon with the $2 Uber chat says she'll pay him with quality luggage. Yeah. So I do like that. I do like that personal responsibility approach. Don't give it to them for an expectation of free. Give it to them with an expectation that they're going to have to pay something sometime. Particularly if somehow she's found not guilty
In the courtroom?
Well,
and the question that Vinny just asked was, do you think she needs to tell her story in the courtroom? Do you think she needs to testify?
Sarah's a unique individual.
See, he knows she's not the easiest of clients. He knows that there's issues with her. She's a unique individual.
I don't know. In a criminal case, it's the time to tell her whole story. I think if it's necessary, she'll take the stand. We're just going to see how the case plays out.
That's the perfect answer for a defense lawyer. That's a top-notch answer there. Don't say yes, she's going to take the stand, or no, she's not going to take the stand. If she has to, she will. We'll just have to see how it goes. Perfect answer.
We'll make that decision when the time comes. Of course, she's got a lot to say. She's filed a lot of pleadings, a lot of letters. Some ill-advised.
We've seen them. Trust me, we've seen.
Yeah.
So James, this is what I want to do. I want to stay in contact with you, and we are legitimately going to reach out to Joseph Krowski to see if he is willing to get down there, if he needs an extra hand. But also wanted to let you know that I wanted to let you go now because I know you've got some discovery. You got a couple more hours tonight. You can jump in there and as you get ready for this. But I hope that we can reach out to you as we get closer and closer to the trial and grab a couple minutes of your time.
All right, that is the introduction to her new lawyer. Well, he filed a motion to continue. That was the first thing he did, was filed a motion to continue, to postpone the trial a little bit. And let's take a quick look at that. There we go. The defense motion for continuance comes now the defendant by and through the undersigned attorney. It's good to see those words attached to Sarah Boone's case. Defendant by and through the undersigned attorney, like a real lawyer, under Rule 3.190F of the Florida Rules of Criminal Procedure, and request this court to grant a continuance of the 3-week jury trial set to begin October 7th, and alleges, here's the reasons that he wants to get the extension. The defendant is set for trial by jury on October 7th. The defendant has just retained defense counsel, and a notice of appearance was filed on Friday, August 30th, 2024. 38 days remain before trial. Well, now we're down to about 28, 29. The defense counsel has met with the defendant 4 times in the Orange County Jail, August 20th, 21st, 26th, and 27th. And Sarah's got to be loving that, because that was one of her big complaints against her previous lawyers, is nobody's meeting with her, nobody's talking to her, nobody's taking her phone calls. He's already met with her 4 times, and the first time for 4 hours. So I think she's got to appreciate that a little bit. During these meetings, the defendant disclosed potential exculpatory evidence. Defendant showed him, Sarah Boone showed him or told him about potential evidence that could exonerate her. So he's saying this is, that we were always wondering, why did she want her telephone so much? Part of it, we were sort of all thinking along the lines of she wants her contact list so she can contact potential witnesses. But he's saying here that the defendant disclosed potential exculpatory evidence on her phone that's in the possession of the Orange County Sheriff's Office. Evidence includes photographs, videotapes, calendars, text messages, notes, and witness names and numbers. The evidence will potentially corroborate her anticipated battered spouse syndrome defense. They've just tipped their hand as to what their defense is going to be. That's seems to be where they're going. There was some questions to whether she would be pleading some sort of insanity or no. She's apparently going to the battered spouse syndrome defense. There was discussion of that, I think, about this time last year, or maybe a little later in the year, a little later in 2023. But she's going with the battered spouse syndrome defense, which we'll talk about later as we get closer to trial. Undersigned counsel has spoken with numerous potential expert witnesses covering a range of possible defenses. Counsel is also actively vetting several additional experts upon directives from interested parties. It is the professional opinion of counsel that the retention of one or more of these experts and the development of the aforementioned defenses is a crucial and necessary component of the defense receiving full and competent representation and due process under the law. Based upon the conversations that have occurred, counsel has learned that proper diagnosis and development of said defenses requires time, not only for administering appropriate testing, but also the necessity that any expert testifying on behalf of the defendant be given adequate time to establish a trusting relationship and then be allowed to apply the analytical tools to the information developed from interviews with the defendant and supplemented with historical and documentary information from the parties. So he's basically saying that, hey, look, we need to bring these experts. These experts are going to be important, but it takes time. They have to get up to speed. They have to build these relationships of trust. They have to examine. They have to analyze. They have to compare. Then they have to prepare their reports. This is going to take a lot of time, Your Honor. We need a serious delay in these proceedings. The process in number 9, as described to the undersigned counsel by renowned and respected experts, cannot be accomplished in the time available before trial, particularly given the JAC ministerial hurdles which must be cleared when dealing with an indigent defendant. Notice of intent to rely on the battered spouse syndrome must be filed 30 days before trial, and that is that's coming up here. That's, I believe, that's coming up in 2 motions from now. So they're going to file their intent to rely on the battered spouse syndrome defense. It must be filed by September 7th or 8th. By September 7th, 8 days away. The defendant has been deemed indigent for costs. The defense will need government funds to assist in paying the experts in this field. Defense motions will need to be filed concerning the potential Brady material. The defendant has the right to be represented by counsel of her choice. The defendant attempted to solicit private counsel after the court's order dated June 28th. The defense counsel responded to her advertisement and was retained. The defendant is not trying to delay the proceedings or abuse the process by retaining counsel at this late date. The defense certifies this motion is made in good faith. And here's the memorandum of law, again, talking about the right to fair trial, right to a counsel, appoint your people. So that's a good motion, a good motion to continue. Then he also, this was on September 2nd, files a motion to appoint a forensic psychologist. Goes through the facts. She's accused of murder. They need the assistance. They're looking to hire a due process provider, a forensic psychologist, to aid in the preparation of the defense, and they need money. This is Dr. Julie Harper they want to appoint. The defense requests the court appoint Dr. Julie Harper, a forensic psychologist, for the defendant. Case rate's $200 an hour, appointed at a rate of $200 per hour for work and travel time, with an initial cap of $7,500. So this is the motion to appoint Dr. Julie Harper to assist the defense as a forensic psychologist. The next motion they filed was the motion to appoint a crime scene reconstructionist and death investigator. Well, again, second-degree murder charge. Privately retained attorney requests the assistance of a crime scene reconstructionist death investigator to assist with the defense. They want to get Dr. Michael Birkland, a crime scene reconstructionist death investigator, for the defense. Same rates, basically, $200 per hour, with a cap of $6,000, exclusive of necessary costs allowed by statute. Wherefore, the defense respectfully requests this court appoint Dr. Michael Birkland to assist the defense as a crime scene reconstructionist death investigator. And that's when we get to the next thing that was filed. This was on the 6th, so this was 3 days ago. Notice of intent to rely on the defense of battered spouse syndrome. This is a required notice that if you're going to rely on the battered spouse syndrome, as we just read 3 motions ago, it needs to be filed at least 30 days before trial. So comes now the defendant by and through the undersigned attorney under Rule 3.201, battered spouse syndrome defense of the Florida Rules of Criminal Procedure, gives notice of intent to rely on the defense of battered spouse syndrome and states, I'll remind myself, this is short. Okay. She states that at the time of the alleged offense, the defendant was suffering from battered woman syndrome as a result of the physical and psychological abuse the defendant sustained at the hands of the victim, George Torres. Dr. Julie Harper will be a Category A witness for the defense in establishing this condition on behalf of the defendant. Dr. Julie Harper, forensic psychologist, Northwest Florida Psychological Services, 19 years. They're here. So that's... they're going to call the expert witness, Dr. Julie Harper, to testify about the issue of the battered spouse syndrome. Now, I forgot about this. I don't know why I forgot about this, but at the end of the lawyer's interview, is there anything else you want to bring up? Is there anything else you want to mention? He did something that a lot of you took notice with. A lot of you took exception with. Let's scroll up here through chat where I hate that he slams George and wants to paint him as a bad guy. She is evil. I think she was the abuser. He did that at the end of his statement. He basically said, look, George abused her. George's brother is now in jail for assaulting. It was just for assaulting a woman, wasn't it? He didn't kill the woman, did he? For some reason, it just slipped my mind. But basically, he said that George's brother is now in prison for doing the same thing, or in jail for doing the same thing, basically, for being an abusive person. So he tried to make this connection that because his brother's doing it, George must also be doing it. It's a thing. That ain't coming in trial. That's not coming into trial. He just wanted to get that out there. Don't worry, there is no way in hell that would be allowed in a trial. Oh, he did. He killed her. That's right. I couldn't remember exactly. Yes, he killed her. Still had the. Oh, that was right. Oh my God, yeah. That was right. Yeah, the knife was still in her skull. That's right. No, you're correct. I remember now. It was the knife in the head thing. So they're saying his brother killed someone, so that his brother is an abuser. So he is. That was the implication, that he is too. Again, that's not coming in trial. That part of it, that because his brother did it, he probably did it too. That ain't coming in trial. It was something he just wanted to get out there. He just wanted to say it. Good defense strategist. That's what a good defense lawyer would do. Now, one thing that we'll see as we get closer to try and rewatch the interrogation videos or the police interview videos, you'll see that apparently both sides have been accused by the other repeatedly. That's not the day that this event happened, was not the first time the cops had been to that house for abuse issues. they've showed up times where he had marks on him. They showed up times where she had marks on her. It did not seem to be the best of relationships from either side. But some of you took exception with that statement by the lawyer about George's brother and the implication that they're connected together somehow. There was a couple more comments similar to that. I just kind of highlighted a few of them. Let's see how. Their evidence is George's brother murdered his wife, so rightfully so. George is dangerous too. Hope they have better than that. Yeah, the video is pretty bad. The video is pretty bad. The defense lawyer is going to do his best, but he's got a lot of hurdles to overcome. And Tirdad Darakshani, sorry. So this first substantive public move is to declaim that George was a violent would-be killer, just like his brother. ... Yeah, he didn't do that. That is correct. And of course, Bifron says the video she recorded is tough, I think, for a jury. Yeah, it's gonna be incredibly tough to overcome that. But that's what the battered spouse syndrome. That's where the defense is going to be coming in. And the battered spouse syndrome isn't she didn't do it. So apparently they're not going to be denying she did it. It's going to be that her actions were a result of the battered woman syndrome. So that's, again, I said that kind of gives you a little bit of a view of how they're going to argue their case. Not that she didn't do this, but because it was a compulsion as a result of this other behavior by the deceased. Unhung Hero with the $2. Can she pay in Samsonite gift cards? Island says the potential exclusion of battered spouse thing bothers me. She openly wanted that defense since the beginning and fought to get an attorney who would argue it. It looks like it's coming in. It looks like that's what they're going to be arguing. We're just going to have to wait and see how this thing turns out in the end. But they asked for this continuance, and we'll eventually get to where it's denied. The dates are the dates. This is still scheduled to be going forward. But there's a reason I asked this in chat in the like and subscribe poll we've got here. The like and subscribe poll today that we started about an hour and 39 minutes ago is: will the trial ultimately be delayed? Why would I ask that? Why would I ask that if the judge has already denied the motion and said he's going ahead on October 7th? But in the meantime, before we actually answer that question, 54% of you say yes, it will ultimately be delayed. So more of you than not think that it still actually will be delayed. And 47% say no. So 53% now yes, 47% no. We'll see. And that's pretty much, that's like plus minus 2% from where we started. So it seems like the trend is holding steady. So why did I ask that question? Well, also on September 6th, what was filed was this interesting document. Now, remember, this is supposed to be a 3-week trial starting October 7th and essentially ending up, wouldn't that be weird? What day is Halloween? Halloween is Thursday. This could end on Halloween. There's a potential that this case could end on Halloween. I think the judge wants it done by the 25th, but what if it goes over a few days and ends on Halloween? So it's supposed to be a 3-week trial, should be done by the end of October, but this interesting document filed here. A notice of unavailability. This is the assistant state attorney. So this is the prosecutor Comes now the undersigned assistant state attorney and hereby gives notice that he will be unavailable for depositions, hearing, and trial beginning December 16th, 2024 through and including December 20th, 2024. That's interesting that although this is supposed to be wrapped up by the end of October, the prosecutor is telling the judge that he's not going to be available for trial in the middle of December. So it seems like even the prosecution is sort of hedging their bets on the start date of this trial. They're not ruling out the possibility it could get bumped back 2 months. Just a little food for thought there. So that's the motions, and more motions. Let's see if we have anything else here to read before we get into the hearing, the most recent hearing that was held. I think we've got everything read. Yes, we have. We have all of those chats read here. Halloween and 4th of July are good birthdays. Well, my birthday is July 5th, so that's close enough to the 4th. That's close enough. I said, for the first 7 years of my life, I thought the entire country was having fireworks displays and parades to celebrate my birthday. Thanks, Dad. That really messed me up. Right. So let's look at this hearing. This hearing was interesting. Now, see, I wonder. This is something I've been thinking about. She was allowed access to this computer for all this time because she didn't have a lawyer. She was given special dispensation to do things because she didn't have a lawyer and she was representing herself. But now that she does have a lawyer, how is that going to affect her ability to use her laptop? Will she still have access to her laptop while she's in jail on the original schedule that they allowed when she was only representing herself? Is she going to be in handcuffs in the court? Because the judge said that you'll sit at the defense table. You won't be in handcuffs, but you'll still be in leg irons during the preliminary hearings. But when the trial starts, you will have a shock bracelet on your ankle. But now that she has a lawyer and she doesn't need to sit at the defense table, will she be in handcuffs still during the preliminary stuff? Let's find out. But first, Jariah with a $2 super chat. Thank you so much. Guest is asleep. Give him scritches later. Yes, we'll have to scritch we'll have to scritch the guest later. Yoda went outside to sleep. Strawberry just died here. So, okay, let's bring up the hearing, and this will finish us off today. Right. Let's see. Share the window. Ladies and gentlemen, let's begin. We got to skip through a little bit here. Oh, before we skip a little bit here, we've got a very important announcement from Duncan, Idaho, who's been a member for 18 months. Thank you so much for being a member of the Clean and Sober crew for 18 months, Duncan, Idaho. All right, payday is here with my monthly membership chat. Woohoo! I'll be sure to follow a strict budget and save it until I have something cool to say. Well, as you see fit. All right, I think that's where we are. The great seal of the state of Florida. In God we trust. I'm gonna fast forward here. So this is where we learn the first answer. She sits down there. She is not sitting at the defense table anymore, and she is still in her handcuffs. That's one thing that has changed a little bit since the last hearing. And she's smiling. That's a good thing. Looking at the camera. Hey, hi, Sarah. She's laughing and joking with someone. That's a look we haven't seen. Oh, there we go. There we go. Mugging.
That person go ahead and swear you in.
Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes. Ma'am, good morning. Could you state your full name and date of birth for record for me?
Sarah Boone, 10/10/77.
Good morning, everyone. We are here on several different items. The first is the court's notice of hearing that was sent out last week. The first issue on that was addressing the viewing of the physical evidence here in open court. On August 5, the court entered an order setting forth certain deadlines and scheduling, including the viewing of the digital evidence no later than September 3, and the physical evidence viewing to take place here in open court on September the 3rd, and a schedule for objections thereafter. The digital evidence review took place on August 9th, and the August 23rd deadline for objections has since passed. On August 14th, the court was advised of an alternative arrangement and advised the state to file a notice reflecting when and where and how that review would have taken place. I did not receive or see such a notice in the court file. Mr. Cashore?
Yes, Your Honor. We were not able to file the notice prior to today. However, on Friday, August the 30th, we were able to have that evidence review of the physical items with Ms. Boone at the Orange County Jail.
Okay, all right. Ms. Boone, can you confirm if in fact that viewing took place?
It took place.
Okay, all right, very good. And
Okay, so the someone asked a little bit up here in chat. It was Ronan Varheit said she's testifying right now. Well, she's the defendant and she has to answer questions like this during the hearing. So she is put under oath, and anything she says can will be used against her during this, and she has the right not to incriminate herself and all those other things. So that's why she's put under oath here. Because she has to answer the questions such as this. They said that they reviewed the physical evidence with you. Did that meeting take place? Yes, it took place.
who did it take place between the state, yourself,
So
and
she is in
Mr.
fact
Lang,
testifying
who were
in a certain way here.
a part of that viewing?
Correct.
Okay, all right, thank you very much. Also set for hearing this morning was defendant's motion for payment of costs and appointing neuropsychologist to assist the defendant.
All right, the
in preparation
neuropsychologist motion.
of the defense that was filed on the 14th. The next day, August 15th, JSCS filed a response to the motions for payment of costs and appointment of a neuropsychiatrist. Paragraph 10 of the JSC's response reflects that the JSC will not be participating in this hearing. Mr. Owens, good morning. What is your position, sir, with regard to Ms. Boone's pro se motion for costs? Are you adopting that motion?
I'd like to abandon that one, but substitute it in for two other motions for the appointment.
Okay, so something very, very interesting just happened here. You may not have, this is the first time her lawyer appears in court for her. That's great. So remember, she made that motion for the neuropsychologist, and the judge is asking him, do you accept that motion as a motion in this case? And Mr. Owen says, hell no. No. We're abandoning that motion. No, forget that motion exists. No, we're repudiating that motion, I believe is the wording used. We're repudiating the pro se motion, and instead we're making two additional motions, which was the psychologist to do the battered woman syndrome testimony and the crime scene reconstruction person. So he's saying, yeah, let's forget she made that motion.
Appointment of a forensic psychologist, Dr. Julie Harper, who was on this case previously. I believe she saw Sarah Boone about 6 times at the Orange County Jail. She was working under the direction of the original counsel, Mr. Padilla, who I believe had the case for about 2.5 years. And I think it was set for trial, ready to go, and then at the last minute he withdrew. I tried to call him a couple of times. Haven't been able to find out what went on. I have talked to Ms. Cashman, the last lawyer, but we don't need this neuropsychologist that Ms. Boone had requested, but we do need a reappointment of the forensic psychologist, Dr. Julie Harper. I've spoken with her, a couple of times last week. I text messaged her 4 or 5 times this weekend. She is in agreement to handle the case, to reopen her file. She has sent me her records. I have reviewed them. I've met with my client. I think my client meets the criteria for bad spouse. I believe Dr. Harper, after she gets a chance to re-engage with my client, spend some time with my client, and hopes that she's going to be of that opinion. In addition, I believe it's necessary for the appointment of a crime scene reconstructionist and death investigator, Dr. Michael Berkland, who is from my area, Pensacola, is who I am recommending to be appointed.
What was his name again, sir? I'm sorry.
Michael Berkland. I filed these judges yesterday or last night. I don't know if they're in the court file yet.
I did not see them this morning. I didn't see the motion to dismiss.
Can I push them in?
Yes. State, have you seen them?
I just saw them briefly this morning prior to the hearing.
Thank you. The only thing I saw in the court file, counsel.
Yeah, right, JKD Bug. Just because one brother's awful doesn't mean the other is. Like Cain killed Abel, man.
When I was prepping last night was the motion for statement of particulars, the comments number 2. I have not yet seen these motions.
Judge, I also filed a motion for additional discovery. I don't know if that made it through as well.
Was that also filed yesterday, sir, sometime in the evening?
It was filed at 8:30 yesterday morning.
So I have a motion for statement of particulars filed at 8:10 yesterday, but I do not have the motion for additional discovery filed at 8:34.
I don't know why the court was not able to post that, because they were filed one right after the other.
One's in the court file, and the other 3 aren't. They were all filed yesterday, 19.
Certain things auto-populate and certain things have to be accepted.
Okay.
The statement of particulars and the additional discovery were filed yesterday morning. The motion to appoint the crime scene reconstructionist and death investigator, and the motion to appoint the forensic psychologist was filed at 6:10 p.m.
I do see that. As the court previously identified, JCS chose not to participate in this morning's hearing by virtue of their response filed on August 15th. They are not here. Your motions for these various experts report that they were sent to all persons on service list through the e-portal. But I don't know how I can address these this morning without having JCS here. So I will endeavor to coordinate a hearing for these as soon as practical. I understand these needs.
Okay, so what's happened here is you recall that the JAC's response to the neuropsychologist motion was to say, look, she's got to we're not going to be at the next hearing. She's got to prove that it's needed and that she would be prejudiced if it wasn't appointed, and you got to find someone that works within the stipulated fee schedule. So we won't be at the next hearing. Well, now in the meantime, she got a new lawyer that made these new motions, and the judges said, look, we need JAC to participate. We need their input. So we'll put these 2 matters aside, the appointment of Dr. Harper and the appointment of the reconstructionist, the reconstruction expert. We'll put those aside and we'll have a separate hearing with JAC on those issues as soon as possible. So those are being resolved that way. There'll be a ruling on those in the future here.
The address, be advised, this is a trial week for the court, as is next week. But I will do my best to endeavor to try to get these heard as soon as possible.
Well, you're here anyway, TJ. So you're accidentally here, and I'm glad you're here.
Dr. Berkland 2 or 3 times this weekend. The state was able to provide me with some discovery. I think once I filed my notice early Friday morning, I think the state provided a lot of discovery to me. I provided that to Dr. Berkland. I believe he has the autopsy We cannot find the autopsy photographs, which he says are critical. We cannot find the crime scene photographs, which he says are critical to his evaluation. So I know time is of the essence. We've got people working on it, but there is some additional evidence that we need.
So he's saying they can't find the autopsy photos and the crime scene photos. We need those quickly. Fair enough. Either they're somewhere on there, and the prosecution can say, "Hey, okay, this is where they are. This is where the files. This is what file they're in." Or they go, "Oh my gosh, we didn't give you those. Here they are." So either way, that needs to be resolved quickly. And one thing that does definitely need to be resolved quickly: that payday comment. Woohoo! Duncan, Idaho has just dropped 5 Legal Vices memberships on you wonderful, super awesome people. We've got 606 people here right now. 5 of you just got a Legal Vices membership gifted by Duncan, Idaho, and that was Lady Tammy. Congratulations, Terry M. You need YouTube Anonymous. You need to sign up for these gifted memberships so you can possibly get one, because not only did Lady Tammy get one, Susan Redmond got one. Great Success got a membership. And Ronan Varheit got one, and Fawn Mayo got the 5th of the gifted memberships. Thank you very, very much. Make sure you give Duncan, Idaho, super special thanks. And those of you that do not have your gift acceptance turned on, make sure you do, because we have a damn generous chat here. People sling memberships around like they're going out of style. Thank you so much, Duncan, Idaho, for that. You get a ship's bell for that. And back to the motions.
State, what's the status of the provision of the autopsy photographs and the crime scene photographs and provided to counsel?
We provided all of those things previously, obviously, to the defendant, which has been greatly discussed already. When Mr. Owens' notice of appearance came on the case, I instructed my assistant to go ahead and send copies of the document discovery, which is easily available to him, just so that he could quickly have that and not have to worry about getting that from his client or whatever. I believe we also sent notice to as well that if he wants additional copies of the autopsy and crime scene photos or any other pieces of digital evidence in the case, that he just needs to provide USB, and we can go ahead and burn that for him. Again, this is in addition to what's already been provided to the defendant in this case.
Okay, do we have a time frame where we might be able to get that information to him?
If he wants to come back to my office, we can do it this morning / this afternoon.
All right, they got that worked away. They should be in there, so you should have got them, but if you're not, we'll just work it out.
I don't have a USB with me, but I'll find one. This morning, we'll get that done.
Okay, I appreciate you both. With regard to the motion for additional discovery filed yesterday, September 2, 8:34 a.m., state give you the opportunity to review this.
I just reviewed it just now here in court this morning. The state was going to request an opportunity to respond to both this motion and also the motion to the statement of particulars formally and in writing, given the lack of time we've had to prepare to make a good formal response.
Sure. And how much time, Counselor, would you like in order to file a response to the motion for statement of particulars and the motion for additional discovery?
I would ask for at least a week.
Any objection?
No objection.
Okay, all right. The state shall file a response to both the motion for statement of particulars and the motion for additional discovery no later than the close of business 5 p.m. on Tuesday, September the 10th.
Tomorrow.
If hearings are necessary, we'll coordinate those. With regard to the defendant's pro se motion for payment of costs and appointing neuropsychologist to assist the defendant in preparation of the defense, the court's going to deny that as moot based on Mr. Owens' representation.
Yeah, so the neuropsychologist thing, he denied it because it's no longer it's just moot. It's no longer necessary to be. It's no longer alive. It's not a living issue anymore because her newly appointed lawyer repudiated it.
With regard to the motion to appoint crime scene reconstructionist and death investigator,
Thank you,
motion to appoint forensic psychologist, State, are you intending on filing a response to these?
No, we're going to take no position on those points.
Okay, all right.
And this was a good thing. They asked the prosecution if they had any comments, if they were going to file a response to the motion to appoint the forensic psychologist and the reconstructionist, and the prosecution said, "No, we're not going to support. We're not going to submit any motion. We're not going to make any particular comment. It's up to you, Judge." Good on them.
I will have Ms. Barrios, I'll ask the clerk to see if we can push these through the portal today so that Ms. Barrios can reach out to JACS and see if we can get a time frame on when they may be able to provide a position statement or a response to those motions, and then we'll coordinate a hearing respectfully.
Judge, I'm going to want to add one other forensic psychologist, make a request. I want to make sure that there's not an issue about my client Sarah Boone and I manufacturing the defense. And there's a second doctor, Dr. Michael Brandon. I'll spell that out, sir. Dr. Michael Brandon.
B-R-A-N-N-E-N?
He spells it B-R-A-N-N-O-N. He was the forensic psychologist in the Marsha Thompson case. That was the Palm Beach County first-degree murder where she shot and killed her husband. Shot him 9 times. He was laying on the couch. And
the judge is like, I'm not sure which case involving a woman that shot her husband 9 times in the face case we're referring to. There's so many. I'm not sure which one you're talking about. But Duncan Idaho gifted one more Legal Vices membership to who was the lucky winner? The lucky winner was Sheila. Sheila was gifted a membership by Duncan Idaho. Congratulations, Sheila. Welcome to the club. And again, for those of you that are just getting these memberships that didn't hear it earlier on in the day, either a week from this Sunday or 2 weeks from this Sunday will be the September Legal Vices members only stream. So stand by for that. Stay tuned and put it on your calendar when I finally get around to deciding when it is.
was acquitted of first-degree murder back in July of this year. That was a 2019 case, so that took a while to get to trial. But Dr. Brandon testified that a battered woman's experience.
Oh, she was found not guilty.
Affects her perception of imminent danger. And that's going to be a question in this case, whether or not Sarah Boone, at the time of her actions, was facing imminent danger. In addition, Dr. Brandon said victims of repeat violence may fear death in situations others would not.
Or Saturday.
And I've tried to reach out to Mr. Brandon this weekend unsuccessfully.
No, 2 weeks from this Sunday will be the 29th. Don't confuse me. A week from this Sunday will be the 22nd. 2 weeks from this Sunday will be the 29th.
And my intent is to reach out to him. I'm hoping he's going to respond. He claims on his website that he responds within 48 hours. I will be, that's the only other witness I'm going to need an appointment for a forensic psychologist. So 2 forensic psychologists, Dr. Julie Harper, Dr. Michael Brandon, and then the crime scene reconstructionist, Dr. Michael Burke. And then in addition, I would like Billy Lane, who's seated in the audience. He is the investigator on the case. Because of the claims that we're making that she's a battered woman, we need evidence to corroborate that. So
that's the investigator. That's Sarah's investigator there.
There's a lot of
from Prison Break Investigations.
History between her and Torres involving the apartment complex, which is in Winter Park. That was 4 years ago. The ownership of that
Don't chew gum in court.
Changed hands, so it's going to be somewhat problematic trying to get information about who all the tenants were that may have witnessed some of the violence involved in these two. as well as we're trying to get together the 911 calls that Sarah made and others made about the disturbances between that couple. So he's got a lot of work to do as it relates to running down witnesses. In addition, we're trying to get arrest reports of the prior domestic violence arrest of Mr. Torres, as well as the officers involved in their body cams to see if there's any evidence on the body cams that would show injuries to Ms. Boone. So we've got a lot of work to do, but I believe it's necessary for us to prove a viable defense of battered spouse syndrome, that we have cooperation. It's going to take a little bit, but I do need the appointment of that expert. He tells me he's already on. I'm going to have to file something else because it was under Sarah Boone. Now, as the attorney of record, I'm going to have to file something. He says he's still got plenty of hours to work under that original cap. So I'll be filing something today or tomorrow as it relates to that. But that's the only other. Of course, I've been retained, so I'm not going to make any claims for attorney's fees. I'm not making any claims for travel costs, just for these witnesses.
The JCS has already approved, I believe, $10,000 in investigation fees and $1,000 for other costs associated with Mr. Lane. That was at one of our previous hearings. Now, that was when Ms. Boone was representing herself pro se. I can't imagine JCS may change their position with regard to those costs, since they've already said yes, but file it, and we'll try to tee it up for hearing as well to see if they have any position, or it could just be, the order can be modified to extend to you as counsel for Ms. Boone.
Thank you.
All right.
So a little bit of a bureaucratic thing there. She was given this, several $1,000s for the investigator's fees, but now she's got a counsel. So now he's got to file the papers to allow him to be the one to engage and instruct the investigator now that he is acting as Sarah's lawyer.
That takes us now then to your motion for continuance file that was filed.
Now comes his motion to continue, which we know was already denied, but here's his arguments.
August 30th. Court's had the opportunity to review that motion. Any other arguments or statements with regard to that motion? Mr. Roberts.
Judge, I reviewed the state case law relating to continuances and the palpable abuse of discretion when the court does not grant it.
Palpable.
It is critical to my theory, our theory of defense, battered spouse syndrome. As you know, that takes time to develop, especially when the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still, 6 days for Dr. Julie Harper to come back out and visit with Ms. Boone, coupled with this other potential forensic psychologist, Dr. Michael Brandon. He's not going to have time to do that. They've got to establish.
Hey, Sherilyn, have a great day. Hope we'll see you tomorrow.
Run the testing, spend the time with her. And it involves some extensive history. Obviously, that couple was together for 3 or 4 years. I still haven't peeled back all the layers. I've tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement. That was just between the two. So we've been going through that. We're trying to get some medical records where she was stabbed by Mr. Torres in the leg, and some other evidence. It's just going to take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective evidence, witnesses, and 911 calls and arrest reports, and provide that to the 2 forensic psychologists for them to help formulate their opinion as to whether she is, in fact, a battered spouse. In good faith, I believe she qualifies based on my spending 3.5 hours with her Labor Day, yesterday, as well as the other 4 times that I've met with her. I have not spoken to Mr. Cordelia, but I believe that was probably going to be where he was going to go. I was not involved. I don't believe you were involved at that time. I may have been.
Not me.
Okay.
My predecessor was.
But I think it was always ready to go. And for whatever reason, he withdrew at the last moment. And then here we are. But I think it's prejudicial if we're not allowed to present the defense that we believe we have a viable claim, and I would respectfully ask. I'm not asking for, I think most times you come on a homicide case, you would need at least 6 months. I'm asking for 1 trial cycle, 2 trial cycles, sometime at the end of the year or first of next year. I can be ready. I think that will give enough time for our experts to visit with Ms. Boone and formulate their opinions. I'm sure the state's going to want to take a deposition. I think they may have a right to hire their own forensic expert to go out and interview to see if they agree.
Compelling argument.
It's going to take a little bit of time, Judge. I'm thinking 2 or 3 months, and we'll be ready to go. I'm not asking for a long continuance. The good thing about it is Mr. Padilla has done a lot of the work. My understanding he's taken just about all the depositions. I believe they've been transcribed. I haven't gone through all the discovery. She's got the 2 banker's boxes. She has not gone through all the discovery. We tried, but we have not made it. My understanding is a lot of the 2-hour interrogation with the sheriff's department has been transcribed. I haven't reviewed that, but we do have a problem with that interrogation. Now, that's why I made the request about the policy.
Oh, interesting. He's got a problem with the sheriff's investigation. That'll be interesting to hear what that problem is.
Our policy in my county, Santa Rosa County, is a little bit different. Based on my discussions with her, we feel like I'm going to need to file some motions relating to that. So, because of that, but ultimately because, yes, could I be ready for trial on October 7th? I believe I could, but not without the battered spouse defense, because I don't believe my experts would be ready. And so that's instrumental in our defense.
State, do you have any position?
I guess the state would just respond to a few things. Part of this battered spouse defense has been previously investigated with several Ms. Boone's previous attorneys, and in fact, the state did retain an expert, Dr. Tanya Warner, who's on the state's witness list in this case, in anticipation of a potential rebuttal of an attempted battered spouse defense. The state's position would be that we would oppose a continuance at this time. However, the state's not opposed to setting another status hearing sometime next week, possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we wait a week, I've got to file a notice of intent to rely on the battered spouse on Monday. We can't wait a week that the time has expired. If the judge doesn't continue it today, he wants to have a conference next week, but it's too late for him.
What's your response to the rule requiring these battered spouse or battered wife syndrome defense 30 days prior to trial?
You have to give it.
Right, but I mean, clearly when that rule was created, it contemplated that there would be sufficient time to prepare for that defense within 30 days of trial, which is why they gave 30 days, which is why the Florida Supreme Court said that 30 days, not 60, not 90, not 120.
But in good faith, you can't file a notice of intent to rely on the defense of battered spouse syndrome if you don't have a supporting psychiatrist, forensic psychiatrist, that makes that claim. I just can't say, hey, we're going to rely on it, and I'm putting you on notice. I've got to have some kind of authority. I'm not an expert. I think she needs the criteria, but I'm not a psychiatrist.
Dang, this guy's competent. Sounds much different than when Sarah's making the arguments, doesn't it? It almost sounds like this guy knows what he's doing. I like this. I feel much better about this trial now. She seems to be in the best possible hands she could possibly be in under the circumstances.
Psychologist. I can't make that opinion. I've got to have an opinion from an expert before I can follow that in good faith. I can't do it without Dr. Hartman. She needs more time. Dr. Brand needs more time.
All right, thank you. State, anything else?
No.
All right, thank you very much. All right, Mr. Rhodes, it seems like you've already started to dive into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yes.
I'm sure you've read the court's June 28th order, which...
Yeah, this is where he goes. You got into the case. You know the history. You know how long it's been going on. You know about all the delays. And you know when June 28th, when I said the dates are the dates are the dates are the dates. So you knew what you're getting into. Deal with it.
was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This case has been pending for some time. You advised in your motion to continue that you met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order in the judge portion, that trial specially set for October 7th, 2024, and that it would be not continued for any reason, absent extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment, knowing that you were not being appointed, and that by your own representation, you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines
You knew what you were getting into.
were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020 under Mr. Padilla's representation of Ms. Boone. At no point in time did Mr. Padilla file a Category A witness list disclosing Ms. Dr. Harper as a testifying expert, and as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone, as addressed in open court on February 9, 2024. As Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who has expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times sought to be appointed, once by attorney.
Now, see, this what's going on about what's going on here is, and all the people that are watching this late, every now and then they say trigger was Roy Rogers. We already, when you catch up 2 hours from now, you'll understand that we worked that out. But what's going on here is someone was mentioning, I was scrolling up trying to find it. Someone was saying she does need the time. Oh yeah, she deserves. It was dose reality. Truth. If the matter is justice, is not a popularity. It's not a popularity contest. She does deserve representation and adequate time to prepare. And this right here is where the judge is saying, you've had adequate time to repair. And he's going through a laundry list of experts that were previously noted as witnesses by the 8 previous lawyers. He's saying they appointed an expert on this day, for whatever reason, most likely attributable to Sarah's behavior in some cases. Other times the lawyers being conflicted out. All of these people that had been previously retained to give testimony about possible battered woman syndrome defense, they haven't stuck around. So he's given that laundry list of, this person was appointed 2 times, this person was appointed this time. She's had many, many lawyers appointed to do this at the appropriate time, but many experts appointed at the appropriate time to do this. It's like saying now, all these people have been appointed during the past several years, but nope, we didn't get through. So now you're asking for another delay when we've already had people that didn't follow through. He's just like, we're done delaying this for any reason. She's had all these other experts, all this other time to appoint these experts. Now she wants another one. No.
Banquets. Dr. Dury specializes in battered wife or battered spouse syndrome. Once by Dr. Banquets on July 17, 2023 again. by Attorney Hobson on January 1, 2024. Based on the Florida Supreme Court decisions in Middleton versus State.
See, Duncan Idaho says Jorge. Hey, come on, Judge, pick one, Jorge or George. I think I'm gonna start calling him Jorge because when I read it, I read Jorge, but then I have to remind myself that everybody called him George. He called himself George. So yeah, I might just call him Jorge to to make sure I get all my bases covered too. Now it's George. We'll stick with
220-7-3rd-1152 and 1176. Barber v. State 221-7-3rd-562 at 569. There's a two-part test determining the need of experts. We're not going to be addressing that today as you sought to file these other motions that I haven't had really the opportunity to address. And JCS is not here and have the opportunity to review those. In Ramos versus State 75-7-3rd-1277 and pinpoint 1281 by the Florida 4th DCA 2011, citing to Lawson v. State 84-7-2nd-540, also by the Florida 4th DCA in 2004. In that case, defendant Ramos changed his defense counsel at least 4 times while this case was pending, with the latest change in counsel occurring 2 to 3 months before the actual trial date. There's no record
he did go by George.
that any of Ramos's previous attorneys had provided ineffective assistance, and the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role in shortening the preparation time for trial, as set forth in the court's June 28th order. This case has already been continued 16 times. As of the date of your filing of your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days.
But who's counting?
On June 7th, this case was specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent
This is a very, very long way for the judge to say no.
role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation of trial is counterbalanced by the right to the effective administration of justice. As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out, Padilla, Banquets, Hobson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those motions and findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, as established by counsel's representations in various hearings, and prior counsel's motions for attorney's fees, all of which were filed.
Yes, second-degree murder, facing life in prison.
Ms. Boone has had discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you are not court appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15, 1986, with a duly elected public defender of the First Judicial Circuit in the state of Florida. From 2009 to 2012, you've tried over 100 cases to verdict throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As to the battered spouse syndrome of defense, you still have time to file the appropriate notice in accordance with the rule. And considering all the factors as set forth in terms of the state 311-7-3rd-185 and 189, Florida 2nd DCA 2020, your motion for continuance is denied.
Denied.
Matter, this trial is still set for October 7th. We will have pre-trial. The 6th to 27th. Pre-trial in this matter, or trial case management will still be set for September 26th at 9 a.m.
Judge, a couple of things. Number one.
So the next hearing is the 26th, coming up. It's a few weeks. Then I think there's one more pre-trial conference, and then it's rodeo time.
I have a full practice. I've got a docket day this afternoon in Sarasota County for Circuit Judge Scott Duncan. I've got 12 clients that are pending. I've got other people covering it, but I do have a full docket. If we set some of these hearings involving my motions, could I be allowed to hear by Zoom?
Any objection?
No, Your Honor.
The only request I would have, sir, is the rules of general practice require a notice regarding your appearance. If you could just file a motion, then provide a form order, I'll sign it, and you can appear virtually. There's no reason for you to drive all the way down to Santa Rosa County for all these hearings when we can appear virtually. JACS, I imagine.
Judge has got a big old gold ring on that
some of
hand.
these motions with regard to the experts. So as long as you file a notice in advance, sir, I've got no problems with that.
Judge, in that pre-trial order, it mentioned, I thought, that the state attorney was supposed to meet with the defendant and the defendant's investigator and review all the digital evidence from the order. That's the way I read it. They were supposed to sit there all together and watch every potential video exhibit the state was going to introduce at trial. That has not happened. I think today was the deadline for that. I don't mind extending that because I'm going to need to look at the evidence.
With regard to the digital, the deadline, you are correct, sir. The deadline was today, based on the August 5 order. If it did not happen before then, as I outlined at the beginning, there was a change to that process. A thumb drive was provided in open court to Mr. Lane on August 9. He then provided it to Ms. Boone, a thumb drive of the specific digital evidence that the state is seeking to admit at trial, based on the witness and exhibit list that was filed under seal on August 9. Ms. Boone had the opportunity to review that information at that time.
All right, I'm going to ask for more time for me to review the digital exhibits they intend to introduce. I don't know if they've been redacted. I don't know if they're the originals, but I'm going to need to look at that. You know, I went to the jail yesterday. I had let them know in advance that I was coming. I believe my secretary had emailed them and said I wanted to bring in my laptop and my phone to view evidence and whatnot. I was not allowed to bring in my laptop and phone yesterday for 3.5 hours. So I didn't get done a lot of the things that I wanted to get done within that period of time. Probably would have stayed there a lot longer if I would have had that capability. So I would ask for some more time to be able to look, for me to look through the digital evidence as to what I assume it's being redacted. I know some of the audio in terms of clients, comments my client made, comments the officers made, some of it is, in my opinion, improper to be presented before the jury. So I'd like some extra time to be able to do that.
State.
I'm not certain, is he asking for a continuous again? What is the extra time that he's seeking?
What is it you're asking for? Extra time to do what?
The way I understand the order, I'm looking at paragraph 4 of the scheduling order and notice of hearings that, Judge, you signed August the 5th. Paragraph 4, the state's digital evidence will be reviewed with the state's investigator, the defendant's investigator, no later than September 3rd, 2024. This evidence viewing can be done in advance of September 3rd deadline. The state shall provide the defendant USB drive with station. They never viewed it with my client in its entirety. As the order states, they were to do by today. So the state attorney has failed to comply with the court's order. I'm saying I haven't had a chance to view it either. Can we reset that deadline?
Give me a moment. On August 9th, Mr. Owens, we had a different hearing. And at that hearing, we addressed the digital discovery review. Mr. Lane was here. There was a USB provided in open court. And the August 9 order and notice of hearing identifies a change to that August 5 order. Specifically in paragraph 4, prison break investigations by and through investigator Billy Lane shall take possession and custody of the USB jump drive, which contains
Yes, Alan,
digital
that is her new lawyer.
Tendered in open court on August 9, 2024, and shall provide same to Major Malik X. Muhammad at the Orange County Jail today, August 9. Paragraph 6, prison break investigation shall follow a court notice reflecting that the discovery in the USB jump drive, which contains the state digital evidence, was provided to Major Malik X. Muhammad at the Orange County Jail, including the date and time of the transfer. Such a notice was provided by Mr. Lane and filed in the court file. It was discussed at that August 9 hearing as to the revising of the digital evidence schedule. Paragraph 8 states that on August 14th, 2024, 1:30 p.m., a hearing will be held, courtroom 12A, regarding defendant's review of USB jump drive, which contains the state's digital evidence. The defendant's August 7th letter to the court, provided to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024, pertinent case law is attached. On August 14th, we had a hearing, we discussed that, and we identified that she had the deadline until August 23rd to make any objections. Now, under the original scheduling order, which said this matters, which on August 5, which set the schedule for when there would be deadlines for objections, those would be extended by good cause shown. Are you seeking at this point in time to extend the deadline for a period for objections, which has since expired?
Yes.
Okay, state?
No.
Okay. How much time would you like, sir, in order to review the state's digital evidence that it seeks to admit into evidence and tender any objections?
I've got to go buy jump drive. I've got to take it down to his office. He's going to give me that evidence.
Okay.
Obviously, I
With the
need to
evidence.
review it with my client. I've got a flight out of here around, I think, 4 o'clock. I don't know if I can get it done by then, but I don't see the necessity of.
That's the question, Adair K. I'm trying to find the answer to. Does she still have? I don't know if she can or not, because she now has a lawyer, and the reason she got that was because she was representing herself. I don't think so. I don't know. That's the mystery I'm trying to resolve.
An issue, maybe a week prior to trial, whatever that is, a week prior to that Monday, October the 7th, the week prior.
State?
I'm going to be amenable to setting a status hearing that week.
Here's what we're going to do. We'll address any objections to any of the discovery when we have trial case management on the 26th.
Thank you, Judge.
All right. Anything else, Terry Jones?
Give me 1 minute.
Sure. State, anything else?
Nope.
Madam Clerk is going to work dutifully to, it's already done? Excellent. I'll have Ms. Barrios, my judicial assistant, forward these to JC and see if we can coordinate a hearing.
All right.
State will have till close of business September 10th to file responses to motion for statement of particulars and motion for additional discovery. Parties having no business before the court. You'll have a fabulous day.
Thank you, Judge.
Thanks, sir.
Can I have a word with Sarah?
Absolutely.
And that's the end of the hearing. Hello, Yoda. You big lump. Oh, shoot. So we got a couple more hearings left. A couple preliminary hearings. The pre-trial stuff. It's game time unless there's something very, very extraordinary that happens to get an extension. The judge is sticking to it, but like I said, the prosecutor filed a notice that he wouldn't be available for trial in mid-December. So even the prosecution's not ruling out the possibility that there may be another delay in this. But I think it's going forward. I think he's going to stick with it, but let's see what you guys think. That was the like and subscribe poll today. The 602 of you are here. We've got 553 likes. We got about 2 minutes to get 47 more likes. I want to get 47 more likes in the next 2 minutes before we shut this down. Let's see if we can get 600 likes before we shut it down. Why? Just because. And if you haven't subscribed, please do. This is the final grift for subscriptions before we end the stream today. Please, if you haven't subscribed, do me the privilege, do me the honor. Subscribe to the channel. See what we're all about. You'll like us. If you don't like us, just walk away. But still stay subscribed. But I hope you'll love it, and I hope you'll watch us regularly. And if you are subscribed already, please just double check to make sure you're still subscribed to the channel, because YouTube is asshole and sometimes just unsubscribes people randomly for no reason. And like this video and our like and subscribe poll. Now look, the idea you subscribe, and then you vote. There should be an even number of likes to subscriptions. Come on, people. I misspoke. There should be an even number of likes to votes in the like and subscribe poll. There's 580 likes, and there's 720 votes in the like and subscribe poll. That's like 140 of you have cheated. Hit that like button and take the like and subscribe poll before it ends in the next 30 seconds. The like and subscribe poll today, which again, just a stupid little way to remind you to do those YouTube-y things, liking and subscribing, is: will the trial ultimately be delayed? The judges said no. The prosecutor is hedging his bets by filing a notice of unavailability for trial in the middle of December. And it's almost where we started. We started with 54% saying yes and 46% saying no. We've fluctuated 1%. 53% said yes, it will ultimately be delayed, and 47% say no. That's pretty much within the margin of error right there. 50-50, split right down the middle, statistically speaking. We'll have to see how it goes. But for now, the judge is insisting on moving forward with the October 7th go date. We'll be here covering it all along the way. Now, I need to tell you what's coming up for the next 2, possibly 3 weeks. There's some stuff going on that you need to be aware of. One, Tuesday, Wednesday, and possibly Thursday, we are going to wade back into the deep waters of the Sandra Birchmore case. We're gonna take another deep dive into the Birchmore case. Just reading the affidavit in support of the motion for detention was so heavy that we just had to put that aside for a couple of weeks. The Birchmore case is so rough. And again, it involves some names from the Karen Reed trial. It was a murder. A policeman is indicted for murdering a woman in Canton, Massachusetts, a woman that he allegedly groomed from the time she was 12 years old. A Massachusetts police officer has been charged with murdering a woman he groomed in Canton, Massachusetts. First investigator on scene was Detective Lang from the Karen Reed trial. Showing up on the second day was Kevin Albert, the guy that examined the phone data. Was the guy that examined the phone data in the Karen Reed case. So yeah, we're going to be getting into that. What we're going to be doing starting tomorrow, definitely going Tuesday and Wednesday, possibly into Thursday, is we're going to be looking at the indictment itself, the actual motion for detention, and then we're going to be getting into a very detailed internal affairs investigation report. That is, it takes all of the horror from the motion in support of the motion for detention and boosts it several notches because it lists other police officers that were involved with the victim. So that'll be Tuesday, Wednesday, and possibly Thursday. And then what we'll start to maybe look at the Lynette Preston motion in the What the Hales case, because we had the Judge Grudge case and the other case we dealt with for the past 2 weeks. We might look at the newly released deposition of Lynette Preston. We've also got it. We've got other possibilities. We'll see towards the end of the week what we're going to do. But the important thing is, for those of you that don't know, and for those of you that are missing it, every Monday we normally do a Maritime Monday where we look at a maritime accident because that's what I do. That's my bailiwick. That's my wheelhouse, so to speak, is maritime law. So every Monday we normally do a ship collision, ship accident, some shipping news, some sort of maritime related thing. But beginning on the 16th of September, that is next Monday, we will be going for depending how long it goes, for up to 2 weeks. We will be watching live something that most of you have never seen before and likely will never have the opportunity to see again. We will be watching live public hearings on the Coast Guard's investigation into the Titan submersible implosion. Remember the submersible that imploded going down to the wreck of the Titanic last year? The Coast Guard is now holding open hearings starting on the 16th. We will not be having a Maritime Monday next week. We're going to be having a Maritime week and possibly a Maritime 2 weeks. So stand by. Beginning Monday, the 16th, we will be having, we will be watching the Coast Guard's public hearings on the implosion of the Titan. That's what's going on for the next 2 to 3 weeks. So stay tuned for that. And then we'll probably have a good week or so just to chill and relax. But we'll probably watch more of the Lynette Preston deposition just to sort of cleanse the palate and get ready for the Sarah Boone trial, which was for now supposed to begin on October 7th. So let's see where all of this goes. That's just sort of the forecast for what I see on the horizon. All schedules are subject to change depending on how I feel. But right now, let me look at who is streaming and where I can send you off to, because it's time for me to go to sleep. Let's see. Let me get into the YouTube studio. Master of Puppets. Content. There we go. And hey, we are currently at 80,568 subscribers. We need just 2 more subscribers to get to 80,570. That'd be fun. Let's see. hit that subscribe. Now's your chance to hit the subscribe button while I'm figuring out where to send us all to. All right, let's see. Customization. Redirect. We are going to redirect to Flux. We're going to redirect to gosh, there's 1, 2, 3, 4, 5, 6, 7 Mystery Science Theater channels going right now. It looks like Nick Starro is the only one that is streaming live right now that I can see. So we'll go to Nick Starro covering day 125 of the Young Thug Rico trial. Monk Tunk's last day on the stand is what it's called. So let's go find out what that's all about. But first, Equality has been a member for 9 months. Yay, free chat. You and your chat. I love you. Love you too, Equality. You are super, super awesome. And thank you, everybody. That's where we're going to end the show today. We're going to send you over to Nick Starro. Make sure you tell him that Legal Vices sent you, and watch day 125 of the Young Thug trial. That's a wild thing. I wish I could follow that more closely, because every day is just nothing but craziness there. Thank you so much, mods, for doing your modly duties and taking care of each other in the chat. And chat, looking at you, chat. Thank you for your support. Thank you for the super chats, the monthly memberships, the gifted memberships, and thank you, chat, for just being here and keeping each other company. The Vice Squad is hands down the greatest chat on the entire internet. Couldn't do this without you. Wouldn't want to do this without you. You guys are the best. We'll see you tomorrow. Bye now.